the matter of National Iranian Oil Company and Crescent Petroleum Company International Limited and another partner.
Mr. Dewan.
Thank you, Madam. I was about to turn to ground 2, having addressed grounds 1 and 4.
Yes.
But with the court's indulgence, there were 2 small points that I wanted to just wrap up on
Yes,
grounds
by all
1 and 4,
means.
if I may.
Yes, of course.
The first, I thought it would be remiss of me not to refer the court to the specific passage of Okpabi on which I rely in support of where I'm coming from on summary judgment and the mini trial point, which is volume 3 of the legal authorities, tab 33, page 746 to 747, and I just want to show you the specific passage of paragraph 21. It's obviously perhaps well-known guidance as it's described at paragraph 21, but I thought I should refer the court to it. So you'll see at paragraph 21 that what's being endorsed is the well-known guidance set out by Lord Hope in the Three Rivers case. And forgive me if I'm just treading over well-trodden ground, but at page 747, at the top under A, to that rule there are some well-recognised exceptions. For example, it may be clear as a matter of law at the outset that even if a party were to succeed in proving all the facts that he offers to prove, he will not be entitled to the remedy that he seeks. And obviously that's the point on which is my basis. What I say the court concluded in dismissing on a summary judgment basis, and which I say the court was right to do so.
Yes.
The second point, and I'm not entirely sure where this goes, but I'll make it in response to something that my learned friend said, is this. It was said that under Iranian law, potentially, rather than assessing CGC's liability loss to CNGC, what the tribunal should have done was to make a declaration. And that was said to be, I think, generally supportive of the restrictive approach to interpretation. Now, I just want to draw your attention to what NEOC's case was before the tribunal on declarations, because they actually said that you can't get a declaration as a matter of Iranian law. Now, again, I'm not sure where this point ultimately takes the court, but I am drawing it to your attention.
Yes.
So if I can give you the reference, which is the Supplemental Bundle Volume 2, tab 4, page 490, and it's paragraph 44. What is said in paragraph 44 is declarations of indemnity that the claimants are seeking, because in respect to some of the third-party losses, unlike the CNGC claim, declarations of indemnity were being sought. And what is said are, they are inadmissible under Iranian law. And you'll see a footnote to Merpour 1. Merpour was one of the experts tendered by NEOC on Iranian law in the arbitration. So that's paragraph 44 and footnote 29. Now, as I say, ultimately, I don't think that takes the court anywhere on the issues that it has to grapple with for the purposes of summary judgment. So forgive me for that excursion to some extent. Now,
so I suppose you're entitled to your forensic points from time to time.
Thank you, my lord. So ground 2, if I may turn to that.
Yes.
This is the complaint. I'm paraphrasing from para 51 of NEOC Skeleton, but this is the complaint that by using the term literal, the court failed to apply Iranian law because a literal is not the same as restrictive interpretation, because, and what is said is, the words are to be interpreted restrictively, applying a presumption against jurisdiction in respect of disputes concerning third parties. So that's the criticism of the judge's application of the Dr. Mokarami test. as your lordship said, there's what are his principles, and then there's the application. And so ground 2 is concerned with that. Now, the problem in my respectful submission is that it is again eliding and collapsing what I have described for convenience as Dr. Mokarami's step 1, which is textual interpretation, and step 2, which is in cases of ambiguity. In other words, in my submission, this ground of appeal in fact coalesces into the points that I've covered in under ground 1, which is why I said I didn't think it was going to take me very long, which is that Neox's assertion as to what Dr. Mokarami is saying is not in fact what he has said. At step 1, when one is concerned with textual, what he talks about, if the court recalls, strict textual interpretation, what I submit is what the judge has done when he refers to literalism. It's not only synonymous with textual interpretation, but is assuming in Dr. Mokarami's favour the strictest of textual interpretation. In English parlance, literalism is the opposite of a liberal interpretation. In other words, it's a strict interpretation. It is the opposite of a Fiona Trust business common sense approach in favour of one-stop adjudication. So, in my respectful submission, what the judge was doing was making clear that he was applying Dr. Mokarami's approach rather than a Fiona Trust approach, because Dr. Mokarami had made clear that the Iranian principles do not encompass a Fiona Trust approach. So that's my first point on ground 2. That actually...
Can we go back to the passage in Dr. Mokarami's report?
Yes, please.
That you identified as providing for these 2 stages?
Yes. Right. So that's in core supplemental bundle tab 4. Paragraphs 22. My lord, is there a specific point you had in mind, or did you?
No. I just wanted to be sure how this submission fits into what you told us yesterday.
Apologies, my lord.
So in 22, the key word was paramount. That was
the starting point under Iranian law is the words of the arbitration agreement itself. This is because the words of the arbitration agreement are paramount in conveying the mutual intention.
But that, you say, is the stage 1.
That's what I say is step 1, is looking at the words.
And that is you equate that with the judge's literalist
That's correct.
interpretation.
Yes. Can I take it a little bit further?
Yes.
My lord, and forgive me if this is not helpful, but if we could go on then to paragraph 23. So what we have is, after referring to the restrictive approach in line 1, in the third sentence, accordingly, under Iranian law, there is a presumption that jurisdiction is only conferred on to arbitrators to resolve those specific claims, disputes, or controversies that the parties have expressly agreed and articulated. It follows that if there is any reasonable doubt as to whether a particular dispute or claim or controversy comes within the scope in question, it is generally determined against the tribunals having such jurisdiction.
So that's your stage 2.
Exactly. So you look at the text. Is it clear? End of story. If there's ambiguity, generally it's construed against. And in that context, generally, and I did make the point generally, not absolutely. So this seems to be, according to him, generally, it's not an absolute rule. And then at least one can understand where policy points that he refers to may come into play. That's why I say it's at a step 2. And I took you to the passage in Sharavi, which I submitted, reinforced. The text that he referred to, which reinforced that position that you look at the words. And if we go to paragraph 29 as well, this is the other bit I relied on, my lord, and forgive me for going again over
No, I asked you to.
So sentence 2, an arbitration agreement, like any other contract, is only subject to interpretation where there is an ambiguity in the text.
And if there's no ambiguity, it's strictly interpreted. So your submission, just so I've understood it, is there is no tension between what Dr. Mokarami calls strict or narrow or restrictive interpretation and what the judge called literalist interpretation.
Yes, my lord.
They are the same thing.
Yes, my lord. They are. Literalism, he says, in my submission it's a proxy, and as I say, it's the narrowest construction you can give to words in English parlance.
As a general proposition, that's not necessarily true, because sometimes you have words which appear quite general, but you narrow them down by having regard to the purpose of the provision.
Well, that's true by reference to intent, statutory intent, contractual party intent. But what he is saying is you look at the words used to see whether they cover the claim.
Yes.
Another way of putting this might be to say it a purposive interpretation, in the sense of an opposite of a literal interpretation could either broaden or narrow.
Certainly, and that's the Fiona Trust sort of scenario. And he's saying you look at the words for what they mean. And that's what Sharavi also, that he says, you look at the words. So if it says, if the dispute only is concerned, if the arbitration clause is only concerned with performance of the arbitration agreement, then it's limited to that.
Yes.
And then he says if it's arising out of or related to, that's broader, and so forth and so forth and so forth.
Yes, I was just, as my lady said, just pushing back against the notion that in English law,
yes,
literalism always leads to the narrowest construction, because you can envisage cases in which literalism leads to a broader interpretation than adopting a purposive construction, which can narrow what on their face appear to be very general words.
I can see that, my lord. In my submission, what the judge was trying to do, consistently with what Dr. Mokarami was saying, was to emphasize the fact that he was looking at the words themselves without any premonitions or at all regarding, for example, Fiona Trust. And I think his use of the word literalism was to make it at pains that he was looking for the fussy distinctions, as Lord Hoffman called them in Fiona Trust, between words. That's the way I read what the judge was doing in my submission, which was, in my submission, what Dr. Mokarami was saying you need to do.
You start with the plain meaning of the words, and it's only if they're ambiguous that you look beyond that.
Because otherwise I'm not sure what else you can do as your step one. You have to do something.
Yes.
So in my submission, the judge was acting entirely consistently with what Dr. Mokarami was saying you need to do. But forgive me for for pushing the point in a way which can be mistaken for saying something else.
Well, I think I understand your submission, which is that what the judge meant by literalism is what he understood Dr. Mokarami to be saying you should do.
Yeah. Now, of course, there's a further question is, let's assume for a moment that literalism is not the correct term. There still begs the question, given that Dr. Mokarami does say and cites authority for the proposition that you look at the words used, where that takes NEOC for the purposes of this appeal. because you still have to ask the question, what do the words mean? And is there any room for doubt with respect to the coverage of the claim in question?
So, in other words, if the judge was adopting a wrong approach, i.e. not following Dr. Mokarami, we've still got to follow Dr. Mokarami's approach and see where that gets us.
My lord.
And you say it gets us to the same conclusion as the judge in fact reached.
My lord.
Yes.
That is my fallback submission on that.
Yes.
Now, it also said that related to, and this is paragraph 54 of my learned friend Skeleton, has no settled meaning, and that its interpretation will be driven by policy considerations. Now, so I have 2 points on that, which is the question that obviously is not simply what related to textually means, but the term related to in conjunction with all the other keywords in the arbitration agreement. In other words, any, and I emphasize the word any, dispute, controversy or claim, I emphasize all 3 words, arising out of or relating to this contract. So the focus on simply the words related to, in my submission, is too narrow a focus given the ambit of the arbitration agreement. Second, my second point is this. My learned friend refers to English case law pre-Fiona Trust case, pre-Fiona Trust, that address the word related to for the proposition that the phrase related to will be interpreted according to policy considerations that apply. Now, I don't fully accept that as a proposition because of this. If the policy is restrictive interpretations such that the text means what it says and no more, one still is faced with the textual question. It really goes back to what I've just been saying. One is still faced with the textual question. This is, and as I was submitting, this is precisely what was done pre-Fiona Trust, which is that you engaged with the words and you could come up with what was subsequently called fussy distinctions. So, but to be clear, because I think it suggested otherwise, I don't accept for a moment that the present wording, even pre-Fiona Trust, to the extent that English case law is relevant, wouldn't, and driven by the pre-Fiona Trust policy, would not cover the claim in question, being for breach of contract and a third-party liability, the losses arising out of third-party liability. I don't accept, to the extent it's being suggested, that even on pre-Fiona Trust case law, there's an issue here. Now, it's, and I wasn't going to take you to the cases unless that's of assistance to you, given that we're actually concerned with Iranian law. But there's one point I want the court to have in mind, which is that it's a very different situation where you have the same parties under English law that are parties to 2 contracts, which are and the court will be very familiar with that, where you have to allocate jurisdiction, because some of the cases my learned friend relies on for the meaning of related to concern 2 contracts between the same parties, and the court will recall BNP Paribas again in this context, which sets out, and I'll just take you to it just to bear that in mind, the principle of mutual exclusivity, because once you have two contracts between the same parties as part of a matrix of contracts, and you have to allocate jurisdiction between them. So different principles are in play. So so if we just very briefly go to BNP Paribas, which is volume 1 of the, Legal Authorities 1, tab 7, at paragraph 68 on page 115. So, paragraph 68 So if one looks at page 115, 68 little 1, where the parties' overall contractual arrangements contain two competing jurisdiction clauses, the starting point is that a jurisdiction clause in one contract was probably not intended to capture disputes more naturally seen as arising under a related contract. And little 5, this is what I call mutual exclusivity presumption. The starting presumption will therefore be that competing jurisdiction clauses are to be interpreted on the basis that each deals exclusively with its own subject matter. So that's obviously a completely different situation. We're not concerned with that situation. And for example, Satyam, which was one of the cases referred to my learned friend Skeleton, I'm not going to take you to it, volume 4, tab 45, was a case of two different agreements between the same parties. And then X against Y, 2005, BLR 341, volume 5, tab 53, that again actually involved, concerning related to, concerned two contracts between the same parties, and the primary basis on which the court therefore interpreted related to was on the basis that, on that basis. Now, it's true that one of the contracts got novated to a third party so that there was a disentanglement of it being between the same parties. But the court said, well, the construction can't change by reason of that, and even if it was, a tortious claim, not a contractual claim, for contribution arising out of another contract was not related to. But in my submission, none of that assists the court with the task it's faced with today. And therefore, I wasn't proposing to go into any more detail of those cases.
I think Mr. Bailey's more general point
Yes.
is that the pre-Fiona Trust cases show that things which were once thought to be within, things which we now think to be within the scope of the words related to, used to be regarded as not within the scope of those words.
Indeed.
And some of the cases give examples of that.
Yes.
But I think from what you said, your response to that is, well, even giving the narrower view of related to, a claim for damages for breach of the agreement qualifies. Is that right?
That is my submission.
Yes.
Which is, as a matter of text, and ultimately, as I tried to say in opening, and I probably was rushing it a little bit, I said that ultimately this case, this appeal, turns on the arguability of the claim in question not being covered by the language in issue. The arguability of that point.
I have to say for myself, I find all this argument about what relating to means rather puzzling, because the words of the clause include any claim arising out of the breach of the contract.
Well,
this is a claim that arises out of the breach of the contract, and as I understood Mr. Bailey yesterday, he accepted the claim
the damages.
for damages for breach of a contract is squarely within the clause. His point is rather that you have to fragment that claim, and that damages for losses you have yourself suffered is one thing. Damages that you have suffered in the sense that you're liable to pay your subsidiary is something else.
Yes.
Now that doesn't really seem to me to be assisted by asking the question, is it related to? Because it is a claim which arises out of the breach.
But my lord, of course I adopt that, and I began this little passage of debate by saying one shouldn't be focused exclusively on related to, because one has to look at the entire clause, and I focused on any dispute, controversy or claim, and also breach, because it's all there. And so, my lord, of course, I endorse and accept what your lordship is saying and putting to me, which is related to is only but one component of a clause which in my submission clearly covers the claim in question. And how does one then go about saying that having covered the contract claim that one fragments out something.
But that's really ground 3, as I understand. Yes, ground 3.
Well, I'll
You
come
have
on
to
to
split
ground
the
3.
claim into different matters,
Yes.
and that some matters may be within
Yes.
the clause and some matters may be outside
Yeah.
the clause. That's how I understood.
Well,
submission.
I'm coming on to ground 3 very shortly. I would put ground 3 slightly differently, and I'll try and explain why. But can I just grapple with the point?
Wait until you get.
Well, can I just grapple with the point your lordship is putting to me? Because this is the textual point that I'm having difficulty with, which is why I talk about it being whether they have an arguable case on the text. Because once you accept that the claim, the cause of action for breach, on what basis, according to the language, is a bit necessary for the purpose of determining that claim outside by reference to the text. And that's really my point. It also, as I'm going to come to, sort of feeds into ground 3. My lord. So that was all I was going to say on ground 2. So on ground 3, I have a number of points. They're actually quite short, but I hope nevertheless persuasive. Ground 3 is the complaint that the judge asked himself the wrong question by asking, and your lordship has just been putting this to me, whether the claim fell within the arbitration agreement as opposed to the matter, being the determination of CGC's liability to CNGC. Now, I do submit that there are some problems with that contention. The first is, in my submission, when we go to 59.3 of the judgment, so when we go to 59.3 of the judgment, the last 4 lines as to what he was asking himself the question, and when he refers, when his lordship referred to claim, in my submission, the judge was not asking a narrow question as to whether the cause of action fell within the arbitration agreement. On the contrary, he is asking himself the question whether all matters required for the purpose of disposing of the claim fell within the scope of the jurisdiction clause, and most importantly, the determination and quantification of such liability, since that was the very issue in dispute. In other words, when his lordship was referring to claim, in my submission, that was descriptive, and the way it was defined here, it was descriptive of the components of the claim, and not just so-called cause of action. So, and that's why he's broken it down by reference to all of the relevant components that would be required to be established for the purpose of the claim, which is what is accordingly involved here is to ask whether the clause might, etc., and then he refers to the clause, extended to a claim which might in the future be brought by one of the parties for damages which that party alleged that it had sustained by reason of its liability to a third party as a direct result, and he used the word direct because of course that's what the tribunal had found, of the other contracting party's breach of contract. So in my submission he was asking a much broader question as to whether all the matters required for resolving the claim fell within the arbitration clause. That's what I submit he was asking himself the question by referring to claim, not simply cause of action, because according to NEOC, that's not even in dispute. Now,
well, he was picking up the language of the clause, which itself refers to claims being referred to arbitration, as well as disputes or controversies.
Yes, indeed as well, my lord. But what's in my submission, very clear, at least, is that the judge was not restricting himself in some way to causes of action as it's been put on this appeal. Now, and so the second point is this, and this is the section 30 point, which is the judge, in my submission, was perfectly entitled to identify the matter that is subject to jurisdictional challenge by reference to the descriptive term claim as including every element of the claim that needed to be established for the purpose of the claim. The judge was not obliged, and is not, no court is obliged under section 30 in defining matter to express himself with a particular level of granularity. And none of the cases stand for the proposition that the court has to define the matter by reference to a particular level of granularity. It can be the case that there are component elements of a claim that fall outside because they're, for example, inarbitrable, or because it's a counterclaim which classically, where you're talking about set-off, transactional set-off and independent set-off, whether or not that, in the context of an arbitration clause, whether that. But the fact that the judge was making a description of the claim does not mean he had the relevant issue in mind, and nor was he obliged under section 30. And if we can just briefly look at the Ruhan case in volume 4, tab 48. This is Mr. Justice Popplewell's decision, as he then was, at paragraph 43 on page 1145. And at little 4, one of the points made is that in considering the claim, the court should look at the nature and substance of the claim and the issues to which it gives rise. And obviously Mr. Justice Popplewell is saying that in the context of saying, well, there may be a matter which isn't within the arbitration clause. But in my submission, all the court was doing was looking at the claim for the purpose of looking at the nature and its substance to see whether there were any matters which were not covered by the arbitration clause.
Well, actually, I think he's looking to see if there are matters which are covered by the arbitration clause. This is section 9.
In this particular case, in section 9, yes. But it's the same point in reverse for the purpose of section 67 and section 30. And of course, it's well established that a claim, and I think it's accepted by my learned friend, a claim is a matter for the purposes of section 30. Even in the Mozambique case in the Court of Appeal, and I can take you to that paragraph. Let me take the court to it. So Mozambique, volume 3, tab 31. This is another section 9 case, as the court is familiar. So the relevant paragraph so paragraph 95, first of all. So this is section 9 case. As set out above, the search under section 9 is for the substantial issues to which the claim gives rise, including identifiable or reasonably foreseeable offences. And then at 101, you'll see that the conclusion at 101 is that the result is that all the claims against the respondent companies are matters which fall within the scope of the arbitration agreement. In other words, what I'm effectively saying is that Section 30 is there to assist the court to determine whether there is any element of a claim which is outside the scope of jurisdiction, but it's then not there to restrict the court in its description. Now there are two additional points that I want to make. The first is, in my submission, it's a little unfair and unprincipled for NEOC to pick up the judge on the distinction between claim and matter in circumstances where one of the points that Dr. Mokarami was actually advancing was that the claim fell outside of the jurisdictional, the arbitration agreement. The court will recall that I took you to paragraph 26.3 of Dr. Mokarami's report, so that's the supplemental bundle, volume 4, at page 15. Sorry, tab 4, page 15. And you'll see that what is said is any damages allegedly suffered by CNGC are not a direct result of the breach, and is therefore not a dispute controversy, and CNGC's cause of action against CGC is not a dispute or controversy in relation to the terms of the GSPC. Now, it is of course right that the judge didn't permit NEOC to pursue a directness issue, because that was inconsistent with merits findings. But the ambit of the report was nevertheless maintaining a position that not only a sub-issue within the claim, but also the claim fell outside. So in my submission, it was all the more appropriate for the court to consider it by reference to the claim and all issues for determination arising with respect to the claim, given that that was one of the points being advanced. Now, my final point is similar to the point I made with respect to ground 2, which is where this point actually takes NEOC for the purposes of this appeal is not, in my submission, fully articulated. In other words, why, it goes back to the same point as to why on the text this makes any difference if the court had specifically referred to matter as opposed to claim.
Well, the judge was well aware that it was brought as a component of the, in fact, brought as a component of the claim.
Indeed, my lady.
An aspect of the damages claim.
Indeed, my lady. It was the critical matter in issue for the purpose of the claim. But so so my point is, I'm not sure where the point ultimately takes NEOC. So unless I can assist the court further, those are my submissions.
Yes, all right. Thank you very much. We'll.
I did actually have one further question.
I'm sorry.
That's about the settlement agreement. What is the position of a settlement agreement? It does seem to me slightly odd if you had reached agreement with your subsidiary in 2018, but the tribunal wasn't told anything about it at all. Because suppose you had, I mean, I know in this case it's a 65% subsidiary, but suppose it was a fully arm's length transaction. If you'd settled your claim with a third party, that would quantify your exposure to damages. And if you'd settled it, suppose there were real doubts as to your liability and you'd settled it at 50% of the headline claim, that would be directly relevant to the amount of damages you could recover. Well, why is the settlement agreement not something the tribunal should know about?
My lord, we haven't addressed it in the evidence, and I can't give you a clear answer to that. The evidence, I note that the settlement agreement was 2018, according to the evidence. The evidentiary hearing on all these matters took place in 2016.
Yes, but the award's not handed down
till 2021. So I thought my learned friend was not taking a non-disclosure point. I thought that's the way he put it.
No, he wasn't. But in principle, the quantum at which you have settled a third party's claim is relevant to the assessment of your damages.
Unless it's, well, I think my learned friend put it that, sorry, I can't hear what's being said. I think what was said by my learned friend was that what the settlement agreement, so far as they've said in their evidence, and I haven't actually looked at the settlement agreement, I have to admit.
I don't think we have it.
It's not in evidence.
It's not relied on by either side as relevant to any of these issues.
Correct.
But it still seems a very odd position.
I think it was according to the evidence that is put forward on behalf of NEOG, it was I think the way it was put is that whatever, we'll settle for whatever you recover from NEOG. I think that's how it was put.
Yes.
In Mr. Howarth's statement. I can't confirm, I'm afraid, because I have not seen the agreement. And I haven't pursued that simply because it wasn't an issue. If they wanted to challenge the award on the basis that the damages award is that there was a material non-disclosure or something of that nature.
Well, that would be a different challenge. I understand that entirely. Yeah. So you don't...
I can certainly take instructions, but being candid with the court, I'm not in a position, speaking for myself, to give you a better answer.
No. Okay, thank you.
I can, of course, take instructions if it's helpful.
No, well, if neither side relies on it, then so be it.
All right, well, thank you then, Mr. Dwan. Mr. Bailey.
My Lord, while it's fresh in my mind, can I just make two brief points about the settlement agreement point that you just discussed with my learned friend? And they are that my learned friend very properly said he can't give a better answer. There's no criticism of my learned friend at all. I equally haven't read the settlement agreement, I haven't seen it. It was disclosed in a separate arbitration. But my Lord, I wouldn't.
Sorry, it has been disclosed in the Geneva arbitration.
In the Geneva arbitration, yes.
And it's not in evidence before us, although there is reference to it.
Indeed, the point I was about to make is, in fact, it was Mr. Dworski's statement that first raised the point. If you remember, I showed it to you yesterday. He opened the door to this point, and then they've gone extraordinarily quiet on it since. Now, the relevance of the point is that it demonstrates, from a commercial perspective, the difficulty with, in commercial terms, the difficulty with the approach the tribunal took. Because what it does is it opens the door to potential windfalls, whereby a party can essentially do a deal with a third party, but try and claim, go to the tribunal and say, well, actually, there's no claim, there's no arbitration, there's no judgment, there's no award. But here you can look at this contract, we're liable for $8 million. Pocket the money, notwithstanding the fact they've settled for a lot less. And the relevance of that is, I'm not saying that's what actually happened here. What I am saying is what Dr. Mokharami does is that he identifies, and this was before we'd seen the evidence about the settlement agreement, but he identifies that one of the rationales, or one of the policy considerations that Iranian law adopts for the purpose of construing an arbitration agreement restrictively is to avoid the possibility of that mischief occurring. That's the narrow point it goes to. My lord, that's. Can I go back to the beginning, having started at the end? Got a few brief points. The first thing is this, my lord, that my own friend made the point that the arbitration agreement in this case is expressed in the English language, that the question of construction turned only on a few words, and it was a simple one, and therefore this was a paradigm case for grasping the nettle at a summary judgment stage. Now, with respect, we would submit that's not the case, and I had 8 short points, if I may, as to why that's so. The first point is this, that it's of course correct that the arbitration agreement was written in the English language. We've seen it, I think, in core supplemental bundle at page 1. The point there is that the governing law clause expressly provides that the contract should be governed by, and it makes the particular point and interpreted in accordance with the laws of the Islamic Republic of Iran. The second point is...
So what does "and interpreted" add to "governed by"? Is that something you're emphasising?
Well, I'm emphasising the fact that parties made specific consideration for the fact that although the arbitration agreement was expressed in the English language, it was to be interpreted by reference to Iranian law. That may be the consequence of the word "governed" in any event, but it's clear that they went out of their way to use the words "interpreted." It's a short point.
Right.
The second point is this, that Iranian law is very different from English law. In the Perry sense, Iranian law is at the furthest point on the spectrum, we would say, from common law systems such as New York law, which would be much more familiar to common law, lawyers from the common law tradition. The third point is the English words arising under and relating to do not have a settled meaning in the context of arbitration clauses. As the Old English cases and Fiona Trust demonstrate, they can be construed either widely or broadly or restrictively, and that depends upon the attitude and the policy considerations of the system of law by reference to which they are being interpreted. And an important point here, my lord, is this, that what the Fiona Trust demonstrates is that policy considerations, rather than the precise formulation of the words, have the greatest impact upon the scope of an arbitration clause. Now, my learned friend made a point this morning in this context, the effect that the cases pre-Fiona Trust do not support a construction of related to in the way in which Dr. Mokharami says it would be construed in Iranian law. Well, my lord, there is one case I'd like to show you, your lordships. It's already referred to in our skeleton arguments. This case called X versus Y that was decided by Mr. Justice Jackson, as he then was, 2005. It's in Authorities Bundle 5. So, I beg your pardon, I think yes, in Bundle 5 at tab 53. And try and take this relatively quickly. It's page 1236 of the bundle, page 347 of the internal pagination, part 5 of the judgment. Under the heading, does claim 1 fall within the scope of the arbitration clause in the implementation clause? And if I can pick it up on the last 2 words of 1236, Mr. Elliott argues across the page that X's claims for breach of the PDS contract give rise to disputes relating to the implementation contract. Indeed, Y's breaches of the implementation contract arise directly from Y's earlier breaches of the PDS contract. X's claim for contribution is sound in law. Clearly, this disputed claim relates to the implementation contract, even though the claim is founded upon breaches of the PDS contract. That was the argument, and the learned judge rejected it. And the two paragraphs I'd like just to bring to your attention are this, paragraphs 4 and paragraph 7 on page 1237. Paragraph 4, when I look at the PDS contract and the implementation contract side by side, the natural interpretation seems to be that a claim for breach of the PDS contract falls under the arbitration clause of the PDS contract. The claim for breach of the implementation contract falls under the arbitration clause of the implementation contract. It is both bizarre and unnecessary to treat claims for breach of the first contract as relating to the second contract and therefore falling within the scope of both arbitration clauses. And then at paragraph 7 on the next second column, if my analysis is wrong, then X encounters a different difficulty. The PDS contract and the implementation contract were separate contracts between different parties. The fact that A was a party to the first contract but not the second, the fact that X was party to the second contract and not the first, makes it difficult to argue that the claim under the first contract somewhat relates to the second contract. Now, my lord, it doesn't matter. I mean, it doesn't matter a great deal. And obviously, we're dealing with Iranian law. But what I would state is it is an illustration of a decision, even as recently as 2005, where the words related to in the context of an arbitration clause were not construed in a way which meant the entirety of the claim. In that particular case, contribution fell within the arbitration clause. The next point is that my fourth point is that the length of the clause tells one nothing about the complexity of the task of construing its meaning. And one only has to remember, I think it was a case called Fagan, which Mr. Justice Mance decided first instance, a lengthy judgment, and then went to the Court of Appeal, and then went to the House of Lords. And Lord Musto, I think, changed his mind as he expressed it in his speech. In that case, only concerned the meaning of two words. Actually paid were the two words that the whole case depended upon. So it's a short point, but the length of the clause isn't in any way indicative of the complexity of the task.
Just with sorry, I was looking at X and Y. We've got the arbitration clause in the implementation contract in paragraph 13. Just looking to see where we find the other clause in the other contract. Is this one of the same parties two clauses cases? And if so, where do we find them?
I think this was the one that Mr. Devine said originally were the same parties, and one of the contracts was later novated.
Yes.
Yes.
You'll see that at little 5 of paragraph 39, the point being made. Apologies for the...
No, not at all, thank you.
No, I was just looking to see what the two clauses said.
Yes,
I found one of them, but I haven't yet found the other one. That's all.
Well, clause 13, paragraph 13 on page 1232 refers
Yes.
to the implementation contract.
Well, paragraph 13 says that clause 30 applied to both the PDS contract and the implementation contract.
Oh, yes.
And there's something in paragraph 7.
Yes. In other words, the same arbitration clause was in both contracts. In other words, or rather, the arbitration clause in both contracts was expressed in the same terms.
I see. Right. Okay. Now I understand now. So it's yeah, the same clause refers to the contract, but because it's in two contracts, it refers to two different contracts.
Well, my lord, there were two separate contracts. The wording, the arbitration clause in each of them was the same. The point that the learned judge was making was the fact that it would be surprising if both tribunals had jurisdiction over the same issue.
Yes.
And the fact that there are different parties, as it turned out at the end, meant that it would be surprising if the breach of one contract related to an issue arising under the other. It's as simple as that. I mean, it doesn't take it very far, but
Yes.
what it does do is lend credence to the commerciality, if you like, of what Dr. Makrami has said in his report as to what Iranian law, the approach Iranian law would adopt. My fifth point is this, that we can debate the detail, but the evidence contained within Dr. Makrami's report clearly demonstrates that the relevant attitudes of policy considerations in Iranian law are very different to those in English law. The sixth point, and this is important, I'm aiming to develop it in light of my learned friend's submissions this morning, but we would respectfully submit that the presumption in Iranian law that the words arising under and relating to are to be interpreted restrictively does not depend on establishing that those words are ambiguous. That, in our respectful submission, is not what Dr. Makrami says, and perhaps more importantly, it's not what the judge found in paragraph 57 when he distilled his three principles of construction derived from Dr. Makrami's report. The seventh point, my lords, is this, my lady, is this, that the ultimate issue of construction is, in our respectful submission, a complex one, which was not suitable for resolution at an interlocutory stage without the benefit of a fuller inquiry into Iranian law and cross-examination. Whatever the right answer may be at the end of the day, it's not, contrary to my learned friend's submission, straightforward. And finally, my eighth point on this submission my learned friend made is this, that on any view, it was inconsistent with the evidence of Dr. Makrami and the judge's own distillation of the relevant principles of Iranian law for the learned judge to conclude, as he did in paragraph 59.2, that the relevant words of the arbitration agreement are to be construed literally rather than restrictively, and as a consequence have a wide and a broad meaning. And that, with the greatest respect to the learned judge, is inconsistent, we would respectfully say, with the evidence read as a whole that Dr. Makrami presented. The second, so that's my first submission in reply. My second submission in reply is this, that we would respectfully submit that you should reject my learned friend's submission, that the approach adopted by the learned judge was consistent with the guidance in Okabi, because there was no pleading setting out Neok's case on the relevant principles of Iranian law. And I have 2 points I'd like to make on that. The first is this, that although this was a Part 8 claim form, and at the time Crescent's applications were issued, no directions had been given in relation to expert evidence under Iranian law, and nor had there been an exchange of pleadings, as indeed may well be appropriate. But nonetheless, we had set out, as your lordships have seen, a concise summary of the 11 principles of Iranian law on which Neok relied at paragraph 16 of the skeleton argument prepared for the hearing before Mr. Justice Butcher. Now, that skeleton was served at least 8 weeks before that hearing took place, not a couple of days before the hearing. So my learned friends had it in July, and the hearing took place in September. The second point is this, that the summary at paragraph 16, which is reflected in paragraph 27 of our main skeleton for this appeal, was, for all intents and purposes, the equivalent of a pleading. It summarised in concise and clear terms what Neok's case was, and is, and it also gave cross-references to the evidence of Iranian law. There was one error, as we've discovered in relation to Principle 9, but it gave cross-references to the evidence of Iranian law from which it was derived. And the most important point is this, that in our respectful submission, that should have been the focus of the learned judge's analysis, because the questions that the learned judge should have been addressing were, firstly, does Neok's case on Iranian law give rise to a triable issue? And secondly, is Neok's case on Iranian law and on the construction of the arbitration agreement properly arguable? That's what he should have been, in our respectful submission, directing his mind to. Now, the next major submission my learned friend advanced is that the summary of 11 principles of Iranian law on which Neok relied contained a number of glosses and additions that were not supported by the evidence of Dr. Mokarami, and he submitted that 5 of the principles that NEOC relied upon were demonstrably unsupportable. Now, we don't accept that is correct. And if I may, I've got 8 points I'd like to make, very short ones I hope, as to why that's so. The first point is this, that my own friend said that the policies or the rationales, as he put it, that were identified by Dr. Mokarami in his report for adopting a restrictive approach to the construction of arbitration clauses are not to be regarded as principles of interpretation. Now, we don't accept that that is correct, or at least we don't accept that there's a bright line distinction between a policy on the one hand and a principle of construction on the other. And again, taking Fiona Trust as the locus classicus in this area, that case explains why an arbitration agreement governed by English law is to be construed as a one-stop shop. And the reason for that is because that's the essential policy consideration, which is the product of a very strong pro-arbitration bias in English law, which I'm not criticising that for one moment, but that's the source of the strong policy considerations, which mean that that is how arbitration clauses governed by English law are now construed, irrespective of the precise language or the formulation of wording that parties use. So that's my first point. The second point, my lord, is that my own friend took you to the passage from Dr. Shiravi's book, exhibited to the report of Dr. Mokarami, and I think it's in the core supplemental bundle, tab 5J, page 103. Now, as I understood it, what my learned friend submitted was that this passage from Dr. Shiravi's book demonstrates that in Iranian law, it is only if there is any doubt as to the meaning of the words used that Iranian law applies a restrictive interpretation. Now, my respectful submission that that's not a fair reading of what Dr. Shiravi has said. And the reason I say that is because of the very first paragraph, or the first numbered paragraph, on page 103, where he says this, and these are the points that he makes. The following points should be taken into consideration at the time of drafting the arbitration agreement. The first point he makes is this: terms and phrases to be employed have to fully represent the intention of the parties in submission of their disputes, wholly or partly, to arbitration. Parties must assume that their arbitration clause might be interpreted narrowly, and as a consequence, making use of certain phrases which can barely cover all the disputes might be regarded by the court with care, so that a restrictive meaning be construed therefrom. Now, in my respectful submission, that first point that Dr. Shiravi makes is consistent with Dr. Mokarami's evidence, the effect that there is a basic universal presumption in Iranian law that arbitration clauses are construed narrowly and restrictively, which is not dependent upon a prior determination of ambiguity. The third point I want to make is this, that going to the 11 principles of Iranian law, the first principle, I think there was 5 in total, but the first principle that my own friend said was demonstrably unsupportable was principle 3, and it's probably necessary to have our skeleton argument. You can either take it from the skeleton argument that was before Mr. Justice Butcher, but it's probably easier to see it at paragraph 27 of our skeleton for this appeal. That's the paragraph I think my own friend refer to. Now, the paragraphs, the subparagraphs 1 and 2 from paragraph 27, my friend didn't have any issue with, but he started with subparagraph 3, where NEOC says it is a fundamental policy and principle of Iranian law that arbitration agreements are construed to avoid any risk of inconsistent decisions between different tribunals, as this could lead to confusion and or potentially an unjustified windfall. Accordingly, Iranian law construes arbitration agreements narrowly to avoid this risk. Now, in our respectful submission, that is a fair distillation, which is what it is, of what Dr. Makarami said in paragraphs 12 and 13 of his report, which is at page 11 of the core supplemental bundle behind tab 4. It's the last sentence of paragraph 12. The tribunal's assessment and determination of CGC's purported liability to CNGC therefore creates an obvious risk of inconsistent decisions, which in turn could, for example, lead to an unjust windfall to CGC, in brackets, such as where in fact no liability may exist to CNGC under the applicable UAE law. And then the next sentence begins, accordingly. So he's drawing a direct linkage between the last sentence of 12 and the first sentence of 13. Accordingly, applying the proper restrictive interpretation of the arbitration agreement as required under Iranian law, there can, in my opinion, be no reasonable doubt. Now, I quite accept that his ultimate conclusion there can be no doubt, in my opinion, no doubt. I understand that that's not of assistance to the court, but what I submit is a fair distillation in our summary, particularly subparagraph 3, is it does reflect, or certainly arguably reflects, the evidence that Dr. Makrami does give in the last sentence of paragraph 12 and the first sentence of paragraph 13. Now, my fourth point, my lord, is that my learned friend also took issues with principles 4 and 5 of paragraph 27. And if you recall, he took you to a decision of the Tehran Court of Appeal, which is appended to Dr. Makrami's report. And that decision is in the core supplemental bundle we're just looking at tab P for Peter. And it's a very short point, but the key paragraph was one that my learned friend didn't take you to, and that paragraph is to be found at page 154 of the bundle, and it's the first full paragraph on that page.
So this is the lower court rather than the court.
Yes, sorry, that's the lower court. It's where the reasoning is more clearly expressed, and it was upheld by the Court of Appeal. But the paragraph I'm referring to is, on the other hand, the arbitral tribunals considering the contractual relationship between the respondent and Ash Company was the third party, is a matter outside the scope of the jurisdiction and powers vested with them, because nowhere in the arbitration agreement dated 21st July 2013, and that's the arbitration agreement between the claimant and the respondent, a reference can be found to the power of the arbitrators to address the disputes between the parties and said company, i.e. the third party, under the separate contract. And therefore, the arbitral award is inconsistent with Iranian law. And this means that the award rendered is beyond the scope of authority conferred on the arbitrators. Now, what we would respectfully submit is that what that paragraph is saying is that the tribunal in that case had no jurisdiction to consider the contractual relationship between the respondent, who was party to the arbitration, and the Ash Company, who was the third party. And the reason given for that is because the arbitration agreement did not give the tribunal the power to address disputes between the respondent and Ash under the third party contract. Now, I could quite accept that that case isn't as full as English cases, and one can't follow the entirety of the reasoning because the precise formulation of the arbitration agreement isn't apparent. But what I would submit is that case is at least consistent with the principles that we've articulated at paragraphs 27, 4 and 5, and it's consistent with the evidence that Dr. Makrami has given in his report. And it's wrong at this interlocutory stage, we would respectfully submit, to say that that case demonstrates that subparagraphs 4 and 5 of our summary are clearly wrong, if that is the test. Now, the next principle that my learned friend challenges, my next point, which I think I'm on to point 5 of the 8. The next principle that my learned friend sought to challenge was subparagraph 8 of paragraph 27, which provides, in our summary, that the words arising out of and relating to, although wider, are given a restricted and not a liberal interpretation. We've already been through that point, my lords, but then it goes on to say, arising out of means arising under, relating to means sufficiently connected as a matter of Iranian law, and then there's reference to Article 141 of the Iranian Code of Civil Procedure. In order for two claims to be considered sufficiently connected, there must be a complete connection, i.e. the outcome of each of the claims must be effective to determine the other. So in other words, it's the opposite of what Mustin Boyd said. It's the opposite of the English position, which is, well, you can do what you like as regards third parties because it's not binding on them, and therefore it doesn't matter. Whereas Iranian law says effectively the opposite. You can only make a decision in relation to a third party if that third party intervenes or is otherwise joined as a party to the arbitration agreement. That's the point that's being made by Dr. Makrami based on Iranian law, and he gives the reference, as my own friend rightly accepted, to Article 141 of the 141 of the Iranian Code of Civil Procedure. Now, sixth point, my lord, is this, that my learned friend also challenged subparagraph 9. But this is consistent, we would submit, with what Dr. Makrami said in paragraph 23 of his report and the decision of the Tehran Court of Appeal that I took you to earlier. And finally on this, my lord, I think my learned friend challenged subparagraph 10. This is the point, I think my Lord Justice Nugee picked up on this. In the sense that subparagraph 10 of our skeleton does say, when a specific contract or relationship is mentioned in the arbitration agreement, the tribunal's jurisdiction will cover disputes, controversies or differences which arise directly under that contract, but not extended disputes, controversies or differences which arise indirectly out of the contract. Now, it is, of course, fair and correct to say that the judge found that we cannot rely on any principle of Iranian law that is inconsistent with the res judicata merits findings of the tribunal. And that's obviously right, and we accept it. But that does not mean, in my respectful submission, that the principle of construction articulated in paragraph 10 is not relevant to the process of construing the arbitration clause. And the reason I say that is because what Dr. Makrami, and indeed my clients, cannot say and will not say is that the loss suffered by CGNC was not directly caused as a matter of fact by the breach of contract on the part of my clients. But what we respectfully say we are able to submit is that a matter of construction, an arbitration clause does not cover disputes or differences that do not arise directly out of the contract between NEOC and Crescent. So that's why we respectfully submit the subparagraph 10 remains a legitimate principle that's relevant to the task the court is confronted with. And my last point, my lords, on this submission is this, that we respectfully submit that the exercise my learned friend undertook, and obviously I was listening to it carefully myself, we would submit simply served to reinforce just how complex and difficult the process of interpreting this arbitration in accordance with Iranian law is. It's not a straightforward or simple task. And that in itself, we would submit, demonstrates why this is not a case where one ought to be grasping the nettle at the interlocutory stage and that it ought to proceed to trial. What I would submit is this, that what my learned friend's submissions demonstrated is that he may well have some very powerful cross-examination points to put to Dr. Bakrami, but it goes no higher than that. And what I would, if I may, is just respectfully remind you of one particular passage in the Okapabi case, which is in Authorities Bundle 3, at paragraph 110, which is at page 764. And I hope you'll forgive me for not actually having included the separate authority which this paragraph quotes from. But it's actually a paragraph 110 of Lord Hambden's judgment. Contains a statement from Lord Justice Carnworth, as he then was, in the Mentmore case, and this is the point I want to take you to. And it's the very last sentence of the quotation in paragraph 110, which I invite your lordships to bear in mind. And this is where Lord Justice Carnworth, as he then was, refers to Lord Hope's guidance in the Three Rivers. And at the end he says, it is in my view important not to equate what may be very powerful cross-examination ammunition with the kind of knockout blow which Lord Hope seems to have had in mind. I would respectfully submit that that observation is particularly pertinent in our case. Can I then move to ground 4, which is what my learned friend addressed next? And really only got one point to make on that. And that is my learned friend, at least at one stage of his submissions, said that it wouldn't be reasonable to assume that there would be expert evidence and cross-examination on Iranian law at the trial. And all I would submit on that is it's somewhat difficult to square with the evidence that the evidence that Crescent served in support of its applications. And if briefly I could just show you Mr. DeWars's witness statements in Supplemental Bundle 3, so not it's one of the other bundles, Supplemental Bundle 3, at tab 11. It's just 3 short paragraphs. This may fall into the category I think my Lord Justice Mayles describes as forensic points, which my learned friend Duane may have taken, if you forgive the indulgence me doing the same. But paragraph 5C, the directions related to these 2 applications, Crescent considers that they should be listed together for a 1.5-day hearing. Crescent is successful in either application, the Section 67 claim will be disposed of without the need to call expert evidence of Iranian law that would otherwise lead to a significantly longer, more costly and substantially delayed listing of the hearing. And I think there are 2 other paragraphs that touch on this. Paragraph 42, at page 112, 1204, where he says, I estimate that a full trial, according as it does for the extensive examination of Iranian law, will take up to a week of court time, whereas the proposed summary judgment may only last a day and a half. And then finally, my lords, at paragraph 83E on page 1215, Crescent specifically requested in order the time limit in Practice Direction 62 be varied, so that Crescent may serve responsive evidence to other substantive points of NEOC Section 67 claim, i.e. Iranian law expert evidence. in the event that it's not successful in its summary judgment application. So, my Lord, in my respect for submission, it's entirely reasonable to anticipate both that there will be expert evidence from both sides, and that will be tested in cross-examination at a trial. Therefore, there will be a fuller examination of Iranian law, which will undoubtedly assist the court in deciding what is by no means a straightforward point of construction. Well, can I then turn to ground two? And this really just builds on a point that my own friend tried to develop in the context of his submissions on ground one. So what ultimately my own friend seems to be suggesting is that you only get in Iranian law to a restrictive interpretation of the words of an arbitration clause in the case of ambiguity. Now, we don't accept that that's a fair reading of the evidence of Dr. Makarami taken as a whole. But more importantly, the gloss that my own friend seeks to impose on Iranian law is actually inconsistent with the way in which the learned judge himself distilled the principles of Iranian law in paragraph 57 of his judgment. And why I say that is because paragraph 57 of the judgment, the second proposition or principle of Iranian law that the learned judge identified was not predicated in any way upon a prior finding of ambiguity for its application. The second point I make in the context of ground two is that literalism and a restrictive approach are not synonymous, and certainly so, or obviously so. And my own friend's fallback submission on ground two was to say, well, even if the judge got it wrong, you get to the same result in any event if this court asks the question again. Now, in essence, that raises the very same point I've addressed already as to whether or not this is a case where it's appropriate to grasp the nettle at this stage and make a final determination as to the construction of the clause, or even reach a conclusion that my client's case is bound to fail at trial. And in all the circumstances, the reasons I've already explained, we would respectfully submit that's not the case here. I've already dealt with the Old English cases point, which my own friend made in the context of ground two. So if I finally can make one or 2 points in relation to his submissions on ground three. Now, this is the point about the difference between claims and matters. And I can understand your lordship's thinking, well, you know, where does this point really go? It's an interesting point of law, but where does it go? I mean, my own friend says, well, the way to interpret what the learned judge did when he used the word claims is he meant each and every element or issue or component part included in the cause of action. If you interpret it in that way, then what he was saying was that the matter in question, namely the determination of the existence and extent of a liability on the part of Crescent to a third party under a separate contract, was within the jurisdiction of the arbitrators. And therefore he didn't make any error. But the real point we respectfully submit here is that if he'd asked the correct question, would he have come up with the same answer? And that calls into question, what is the correct question? And what we would respectfully submit, the correct question is this: did the parties intend to refer to the tribunal a potential dispute or difference as to whether Crescent is liable to CNGC under a separate contract which included its own arbitration clause and was governed by a different system of law? If you pose the question in that way, then in my respectful submission, it becomes more apparent why the answer is no, or at least for the purposes of this current appeal, arguably no. And for all those reasons, my lord, we would respectfully submit that the appeal should be allowed, then that direction should be given, and if necessary, perhaps agreed, and then turned into an order by this court that there should be, if necessary, an exchange of pleadings on Iranian law and directions for further evidence.
Well, I think if we get to that stage, it's really a matter for the commercial court. Isn't
Well, my lord, yes, and we can have an early CMC in the commercial court. But what I'm trying to say is that this isn't about delay. Very happy to agree directions as soon as we possibly can. So, let's get on with it. Lord, unless I persist further on on my client's appeal, those are my submissions.
Thank you very much. Right. Well, we now turn to the cross bill.
This is the court. I have to obviously deal with jurisdiction first, and I'm grateful to the court for drawing my attention to the Manchester City case.
Yes.
And I will address it. But can I begin by giving the court an overview of my position, which is this. In my submission, the court's rejection of Crescent's Section 73 preliminary objection, i.e. the determination that NEOC had not lost its right to pursue its jurisdiction objection, was not a decision within the meaning of Section 67.4 because it was not a decision disposing of NEOC's application challenging the award on jurisdictional grounds. In other words, I am saying there is a difference between a decision rejecting an award creditor's Section 73 application and a decision upholding a Section 73 application and thereby dismissing the award debtor's jurisdictional objection by operation of procedural bar. So in other words, and I do submit that a decision under Section 67.4 is a decision on the award debtor's Section 67 application and not a decision along the way. Now, I appreciate, and I'll come on to develop why I'm going to invite Lord Justice Males to consider his observations in the Manchester case in light of what I develop. But I appreciate what...
I think it was the Chancellor.
Well, the Chancellor, I believe, at paragraph 39, referred to your Lordship's views.
Yes. Well, just questions asked in the course of argument rather
Yes.
than concluded views.
Yes, no concluded views, but I appreciate that in that case, and I want to take a few points from that case in due course, that there were some obiter observations at paragraphs 39 and 40, that a decision along the way, like a case management decision, that was the one which was ventilated, might be caught by Section 67.4, but the Chancellor described that as one of the more difficult questions which didn't arise for determination at paragraph 40, and I'm going to come on to that. But I will obviously address you on that, and I want to make clear that I will be. But in terms of the order of my submissions, I want to address questions of policy, statutory language, not limited to Section 67, but also Section 69. Because in my submission it does give certain indications, because Section 69 appears to be looking at the decision on the application in quite clear terms, and there's a question as to why would Section 67 be different. Let me just headline the point that way. I do want to look at case law, the ASM shipping case, the Itochu case, and then of course the Manchester City case, and then some wrap-up points on NEOC's contraposition. So I'm afraid it is going to take me a little bit of time to develop. Now, just can I start then on questions of policy? Now, my overarching submission on this is that the policy of the 1996 Act with respect to restrictions on appeal is quite nuanced, and that it is important, and that is important when it comes to identifying where the line is to be drawn under Section 67.4. Of course, we have to look at the language, but there are issues of policy in play, but they're quite nuanced. It would be in my submission, for example, and I'll explain why, in my respectful submission, incorrect to say that Section 67.4 should be interpreted broadly to include any decision along the way in the context of Section 67 to advance a general overriding purpose of saving cost and avoiding delay under the Act, or avoiding delay in the arbitration. And I'm going to, such an overriding or general purpose is contradicted in my submission by a number of other the provisions under the 96 Act, and more specifically, the purpose behind Section 73. And the question arises, which the court is going to have to consider, and I accept it's a question, it is a question for the court, is when restrictions to appeal are imposed under the Act, are they directed at avoiding delay in the arbitration, or at finality and avoiding delay at the end of the applicable process? That's the way I would put it. And that's what I want the court to have in mind when it tests my submissions, as it obviously is going to. Now, the trite but important starting point when it comes to the 96 Act is that the restrictions on appeal are omitted from a number of important provisions. And this has been held by the House of Lords as the court will be aware, as being deliberate drafting. That authority was in fact cited in the Manchester City case, your Lordship may recall. That's the Inco Europe case. Can I briefly take the court to it? It's in volume 2, tab 23. Now, we don't need to take, let me just remind the court of what the question was. That was a question as to whether Section 9 of the Arbitration Act, which concerns, as we've been in fact discussing over the last day, whether Section 9, which imposes stays on court proceedings in favour of arbitration, whether there's a restriction on appeals in that provision, notwithstanding that there is no specific provision. And the court concluded that since there was no restriction in the Act, that was deliberate drafting, so you could seek permission from the Court of Appeal. Now, the relevant parts of the judgment, if we can pick up from, I seem to have got the wrong reference, but let me see if I can find the right reference. Page 592 at Lord Nichols' speech between C and E. And what is said here is many sections in Part 1 provide for application to the court. Some of them restrict appeals from decisions of the court, but some do not. And then reading in the next paragraph, I derived two impressions from these sections. First, the draftsmen were well aware that the source of any right to appeal lay elsewhere, because of course the right to appeal is contained in the Senior Courts Act. Nowhere do the sections create a right of appeal. Reference to appeals are confined to restricting a right whose existence is assumed. Second, when the draftsman wished to limit the right of appeal, he said so. And so the conclusion that is then drawn, reading a little bit further from E, this style of drafting points strongly to the conclusion that where a section is silent about an appeal from a decision of the court, no restriction was intended. Now, so the draftsman must have intended that, save to the extent an appeal was expressly circumscribed, parties to the court decision and the various sections would be able to exercise whatever rights of appeal were available to them from sources outside of the Act, which is, of course, the Senior Courts Act. Now, I won't labour the issue which arose in that case, but just what had happened in light of the Arbitration Act. The court may recall that there had been an amendment to the Senior Courts Act which had been slightly erroneous. What had happened was that basically what had been said was, unless, save where an appeal right is conferred under the Act, there's effectively no appeal rights. Whereas in fact what they intended to do is that where there's a restriction, then that applies. So they did it the wrong way in terms of draftsmanship, and the court identified the error and said that was obviously wrong. But this is the passage that I rely upon as my starting premise, and obviously Section 73 itself contains no restrictions in the language. I should, of course, have drawn your attention to that, but Section 73 itself contains no restriction. So that is in Volume 5 of the Legal Authorities, tab 54, page 1317. Now, of course, I have to grapple with the fact that it is referred to in Section 67, and I'll come on to that. But Section 73 itself contains no restrictions on appeal. So my next point is this. So Section 9, no restrictions on appeal. Now, what does that tell us in terms of policy? Now, we can go back to Section 9, which is in the same volume, page 1, in the same tab at page 1248. But a Section 9 application obviously gives rise to jurisdictional questions, the same sorts of questions as can arise under Section 67, as to whether there is a concluded arbitration between the parties and whether the matter falls within its scope, as we've been seeing over the last day. It can also obviously give rise to questions of waiver. Now, an appeal to the Court of Appeal, and thereafter, as the Mozambique case illustrates, will therefore potentially cause delay to the arbitration, but there is nevertheless no restrictions on appeal. So, again, I would invite the court to consider that in the context of how broadly one draws the line about delay under Section 67. Because if the policy were to avoid delay to the arbitration, if it's as simple as that, then one would expect that Section 9 would contain a restriction on appeal.
Well, Section 9 is a case where there is no arbitration, but rather there are court proceedings, and the question is whether they should be stopped in favour of arbitration.
Yes. And if the court says it should be stopped in favour of arbitration on the basis that it falls within the scope of the arbitration, and forgive me if I've missed a point, that can be appealed without restriction, which would potentially provide for delay in the arbitration proceeding by reason of the appeal, is the point I wish to make. But,
I mean, only if there was a stay on the arbitration in the meantime.
well, that is of course true. That is of course true. But Section 67(2) similarly allows the arbitrator to proceed pending a determination under Section 67. So, in other words, you don't need Section 67(4) for the purposes of the arbitration continuing and dealing. That's the point I want to make, and forgive me if I haven't made that clearly enough. But Section 67(2), I think that's the relevant provision.
Yes.
Allows the tribunal, I mean, this is one of the key provisions. In this case, the tribunal is continuing the indemnity phase, irrespective of this. They're allowed to.
Is anything actually happening in the
Yes,
arbitration at the moment? It
there's a
is.
phase 3
Right.
on indemnities.
I saw it was deferred. I didn't realise it was live.
It's they're currently listing the hearing because the memorials on that have been exchanged and so forth.
Right. Okay.
So,
These are indemnities in relation to other
yes,
subsets.
other, not the liability CNGC. Other third-party liabilities where the loss hasn't.
I thought almost all sales were routed through CNGC. There was one in favour of some.
Forgive me, CGC's liability to third parties with which it contracted. So not all sales were through CNGC, but a large number. What?
Some contract between a further contract away.
if I've stated it inaccurately, I do apologise to the court. I think I've stated there are some contracts between CGC and suppliers directly. There's at least one, if I remember it rightly. And there are some, well, I'm being told two on the other side, and there are some which go through CNGC and which are may give rise to indemnities down the chain, to the extent that's relevant. Anyway, yes. Sorry, I've slightly diverted myself.
The 67.2 is concerned not with an appeal to the Court of Appeal, I suppose it may be invoked there, but you can get on with the arbitration while the proceedings are pending in the commercial court.
Exactly. You can, but my point is that in the context of section 6.9, the point was made that, well, that doesn't, unless there's a stay, there's no delay to the arbitration because they can get on. That is, of course, true, but the situation is the same under section 67, which is the tribunal can get on. And the question, all I'm asking the court to bear in mind is that I want to constantly test where the line is to be drawn, as it was put in the Manchester City case, as to whether it's decisions disposing of the jurisdictional application under section 67 or along the way in circumstances where the tribunal can continue to act notwithstanding the challenge. That's the only point I'm posing. And sections 9, no restrictions on appeal, so there may be delays in the final determination of the question of stay. Sorry, of the question of substantive stay under section 9. Yet there are no restrictions on appeal. So is section 67.4 concerned with finality at the end of the process or everything along the way? It's the point I'm seeking to pose. Can I ask the court to equally consider in this context, and there is a point of distinction, but let's analyse that point of distinction, section 66 and 103. Now, section 66, which is at page 10307, and section 103, which is at page 1350. Neither of them have restrictions on appeal. Now, the court will obviously be familiar with these provisions. In fact, if you look at section 66, it even cross-refers to waiver under section 73. You'll see that in subsection 3. So these are the provisions for enforcement of the award, recognition and enforcement of the award, a critical part of arbitration in my submission, which is enforcing the award. Section 103, section 66 is concerned with London-seated awards. Section 103 is, of course, concerned with New York Convention awards, in other words, foreign-seated awards under the New York Convention. It enshrines the New York Convention defences. So both of them obviously give rise to questions of jurisdiction, and there are no restrictions on appeal. Now, my point is this, for consideration of the court. If delay along the way to the section 67, delay along the way was an important policy, it's slightly surprising that there are no restrictions on section 66 and 103. Because one of the key points of getting through the challenge process, if I may put it that way, under section 67, 8 and 9, is to be able to enforce the award. So, which is why I pose the question, again, whether it's really about a policy of avoiding delay along the process, or policy of finality and avoiding delay once the process has been exhausted. Now, your Lordship, Lord Justice Mayles, will be familiar. I'm afraid I'm going to refer to two of your cases, which you may recall, but I can take you to them. There are two cases I argued where the first is Kebabji, which went to the Supreme Court. I don't know if your Lordship recalls. So it went to the Supreme Court. It's on New York Convention, section 103.
I I don't think that was me. So,
No,
anyway,
well,
I don't recall.
you
it.
gave the permission to appeal from the court, by the Court of Appeal.
Oh, no, well, that's very possible. Yes, all right.
You gave permission. No permission was sought at first instance, and that was a classic jurisdictional question under Section 103. Bog standard, and that was an ENCA type question as to what is the applicable. How do you determine the applicable law for the purposes of Article 5(1)(a) of the New York Convention?
Mhm.
Your Lordship gave it. There was no. So that's a classic example. Tatneft. Sir Andrew Smith, as he then was, versus Ukraine. I argued that before Mr. Justice Andrew Smith, and I won on waiver. He refused permission to appeal on waiver. It was again a Section 103 case. Your Lordship gave permission to appeal on the waiver point to the other side, notwithstanding the rejection, because under Section 103 there are no restrictions. And so I'm just posing the question as to where we're drawing the line in light of the fact that there appears to be no policy of avoiding delay from getting from an award to a judgment in that sense. So, now, can we then turn to Section 73? I've already made the point that Section 73 has no restrictions on appeal. And I do invite the court to consider why that is the case. And in that context, I do want to take up the DAC report on Section 73, if I may, very briefly. Because it does enshrine, waiver is obviously a fundamental principle of international arbitration. And it is worth looking at the DAC report, which is in Bundle 5 of the Authorities Bundle, tab 60. So the relevant page is 1496 at the bottom. And the relevant paragraph is 297 under clause 73. And I just want to look at the way it's. I just want to look at the way it's drafted, what has been said here, because it's of some interest in my submission. Recalcitrant parties, or those who have had an award made against them, often seek to delay proceedings or to avoid honouring the award by raising points on jurisdiction, etc., which they've been saving up for this purpose, or which they could and should have discovered and raised at an earlier stage. And then it goes on to say, and this is still relevant, Article 4 of the Model Law contains some provisions designed to combat this sort of behaviour, which does the efficiency of arbitration as a form of dispute resolution no good. And we have attempted to address the same point in this clause. In particular, unlike the Model Law, and this is the point I want to get to, we have required a party to arbitration proceedings who has taken part or continue to take part, without raising the objections in due time, to show that at that stage he neither knew nor could with reasonable diligence have discovered the grounds for his objection, the latter being an important modification to the Model Law, without which one would have to demonstrate actual knowledge, which may be virtually impossible to do. It seems to us that this is preferable to requiring the innocent party to prove the opposite, which for obvious reasons might be difficult to do. Now, what is of interest is the classification, in my submission for the court's consideration, is that in terms of policy classification, the award creditor is treated as the innocent party because it's got an award, a res judicata award subject to potential challenge which would remove the res judicata nature of the award. And the award debtor is treated already either as the recalcitrant party or who has an award made against them, and that the policy of Section 73 in terms of how it's been drafted is against them. Now, so from a policy perspective, I am submitting to you, and I haven't yet even got to the language of Section 67, one can see why, or at least in my submission one can make the argument, why not imposing an appeal restriction under Section 73 promotes the specific policy under Section 73, which is a policy in favour of upholding the award and not permitting a the award debtor from holding points up its sleeve and to reopen the award on that basis under Section 67 or Section 68. Now, so to put it another way, in my respectful submission, one can see why the Act would perceive the cost and delay engendered by second appeals as acceptable in pursuit of a policy of not allowing a party to raise objections at the challenge stage that it could and should have raised before the tribunal. That's the point I'm putting for consideration to the court. Now, if we then look at the Manchester case, I just want to start at the beginning of the relevant paragraphs that your lordship drew my attention to, and just
Well, do whatever you want.
No,
Yes,
no.
you know, just
Apologies, my
make
lord.
sure-
I don't mean it in a specific way. If I may, bearing in mind the policy points that I brought to the court's attention, can we look at the Manchester City case?
So your policy point, in a nutshell, is that you can see why the Act would want to stop a second bite by the award debtor, but that does not apply to the award creditor, or doesn't apply in the same way. Is that it?
Yes, my lord.
I see.
It is that.
Yeah. Okay.
And my other policy point, though, goes to the question of whether Section 67(4) is drawing a line at the end of the process or along the way, because I have sought to draw the court's attention to provisions of the Act which tend to suggest that it may be focused at the end of the process as opposed to along the way, because there are other mechanisms for dealing with delay in the arbitration along the way, and the surprising lack of restrictions on appeal under Section 9, 66 and 103, which you would expect if delay along the way of the challenge process was a policy consideration. So there's sort of one underlying in the context of Section 67 and one specific to Section 73, if I can put it that way.
Mm-hmm. Thank you.
Just before you leave
Yes.
the policy point, picking up my lord's point, your submission is that if you had succeeded in your Section 73 objection, that would be a decision, a final decision under Section 67(4), and NEOC would require the permission of the High Court to appeal. But since you failed, you don't require the permission of the High Court. You can ask this court for permission.
Yes.
And you say that's supportive of the policy, which is to uphold
Favour of the
awards.
awards. Yes.
But if you leave aside Section 73,
Yes.
when you get to the substance of a decision under Section 67, the same restriction applies whether you win or whoever wins or loses. That is right, isn't it? So there's no policy. So if you'd lost the substantive Section 67 point,
Yes.
you were seeking to appeal,
Yes.
you would need Mr. Justice
Yes.
Butcher's permission.
Yes. And
So that seems a bit odd, that when you get to the end of it, the policy is the same for both parties,
Yes.
whether you're seeking to uphold the award or
Yes.
disturb it. But along the way,
Yes.
you say the policy is different.
in the context of Section 73, yes, because of the positive policy at that stage in favour of the award creditor at the end of the process, what I submit is happening is that there's a policy of finality at the end of the process either way. The asymmetry, of course, the asymmetry that your lordship is identifying arises out of the nature of a procedural bar. On a substantive determination on Section 67, a determination either way disposes of the Section 67 application. A procedural bar, that you, as the court is aware, there's two procedural bars. There's waiver, Section 73, and there's also extensions of time, which are also cross-referred to in Section 67 and 68. That's a Section 70 bar, if you don't bring your challenge within 28 days. That also only operates one way. So the asymmetry is created by, in my submission, the nature of the challenge, which is it only affects Section 67 one way.
I understand that submission.
Yes.
That there's a difference between you succeeding under Section 73, which is that's the end of it, and you failing, in which case the case trundles onto a hearing. But I don't, for my part, find it obvious why that asymmetry, which is driven by what you say is the nature of a procedural bar, can also be explained by what you say is a policy of upholding awards, because it does seem very odd to me that policy should kick in at the interlocutory, the procedural bar stage, which is your submission, but not at the end of the day. I mean, either there's a policy of being nicer to award creditors and award debtors, or there isn't.
Well, ultimately, it's about a policy supportive of the award and the award creditor under Section 73, which is why there's no restrictions in Section 73 and only Section 67. I also do, well, I've already made the point. I also submit it's just very odd if Section 67 was drawing a line about every application along the way, why you don't have these restrictions in these other provisions. It's quite odd because they're all supportive of the avoiding delay and getting to the award creditor, whoever that might be, getting their award in force. They're all about, all of it's part of the machinery of arbitration in my submission.
Thank you.
I know I've not fully addressed your Lordship's concern, but if I may park it for a little while and see if I can come back to it in the context of some of the other points I'm going to make, and see if it potentially assists. So can I just go to the Manchester case for a moment? I only want to take a small part of it at this stage in the policy argument, and then where is the Manchester case? Has that been handed up? Oh, thank you. Lovely. Thank you. Now,
Thank you.
if I may remind the court of the facts anyway, because obviously Lord Justice Mills is perhaps more familiar than his learned friends, or rather lordships. So the case actually was concerned about whether you could get permission to appeal on the question of publication of a judgment in respect of a Section 67 decision. And the court concluded that that publication point is not a decision for the purpose of Section 67.4, and therefore you could seek permission to appeal on the question of publication from the Court of Appeal. Now, in the context of that, as I say, there were certain discussions had as to where you draw the line under Section 67. And the point I want to make is, and I hope the court will accept this, but I do take issue with the starting point on policy that is expressed at paragraphs 31 and 32. And let me explain why, with the greatest respect to what has been cited to the court. Now, at 32, what is said here is that it's trying to draw the line as to where publication fits and why it's not a decision. And what is said in the third sentence is this conclusion was supported by the policy reason for the restrictions in each of these sections.
Sorry, where
I apologise, my lord, I'm taking it too quickly. Paragraph 32 from letter C on page at the top 5521.
Oh, second, this conclusion. Yes.
Second, apologies. This conclusion was supported by the policy reason for the restrictions in each of these sections, which was to limit further appeals because they would lead to delay in the resolution of a dispute decided by arbitration.
Is this a recital of Lord Panic's submissions, or is this part
Well,
of the decision?
So I think Lord Panic was making that submission that was the policy, and it was being done by reference to an observation by Lord Justice May in the Amick civil engineering case. And I need to take you, so if you look at the passage on Amick, it's can I explain? I have got copies of Amick, and I inform my learned friend of this. But let me explain what Amick's about and what was the observation that was drawn from it. So Amick was a case concerning whether there was a dispute which could be referred to arbitration, or whether it had been prematurely referred to arbitration because there was no dispute. I think the arbitrator was Lord Justice or Mr. Justice Ramsey, sitting as a member of a tribunal, and it went to a first instance judge. He agreed with the arbitrator that there was a dispute for the purposes of Section 67 and therefore could be referred to arbitration. But he gave permission to appeal to the Court of Appeals. And what Lord Justice May actually says, and I'll take you to the passage in a moment, is that he considered that the judge was wrong to have granted permission because, and we can pick this up on page 5522 in the quote, between letters A and B, he thought he was wrong to do so, or he says, I'm not convinced he was right to do so, because the policy of the 96 Act does not encourage such further appeals, which in general delay the resolution of dispute by the contractual machinery of arbitration. So the broad policy, which I question, the breadth of the policy has been drawn from this comment regarding the judge being wrong to grant permission to appeal. As I've said, in terms of such further appeals which in general delay the resolution of disputes, I question that in the sense that Section 67(2) has already got a provision. I hope the court will accept, I mean that with the greatest of respect, that I raise an issue as to whether this has been the correct policy line that has been drawn in this case.
It does look like this is part of Lord Panic's submissions, though. I may be wrong.
I think that's how I read it as well.
Well, forgive me. Then I'm saying Lord Panic's wrong.
I mean, obviously he's quoting Justice May, is it?
Yes.
So he's got something behind him.
He has, but that was very much an obiter observation as well, bearing in mind that all that the Court of Appeal was concerned with in Amick was the question of whether the appeal on Section 67 was correct or not.
Well, the policy is not so much to discourage appeals to the Court of Appeal, but to make the High Court the gatekeeper for such appeals. And although Section 67 doesn't say this, Section 69, for example, makes clear that you only give permission in more limited circumstances in arbitration cases than you might in other cases.
Yes, but entirely accept that, and I'm going to come on to Section 69 in a short moment. I suppose my point for present purposes is that when one gets to the debate at paragraphs 39 and 40 of this judgment, and we'll come on to Peel and Cole in a moment, but citation of those cases provoked a debate between counsel and the court as to where the line was to be drawn between decisions which would be caught and decisions which would not. Lord Justice Mayles posited the example of a case management decision about how a Section 68 application should be dealt with. As I said at the time, this would seem to be an example of something which is part of the process of reaching a decision under Section 68, so would be caught by the limitation. And then, but ultimately, as your Lordship has already pointed out, paragraph 40, what the Chancellor says is that if we look on the next page at A, I agree that it is not necessary for present purposes to determine the more difficult question whether case management decisions either side of the substantive decision are caught. And the reason why I put it, why I've started from the position of policy, because if the policy is to avoid delay in the arbitration, then if that were the policy, then I can understand why one would draw the line broadly. But in my submission, it isn't as straightforward as that, and that the policy is more limited than that.
The specific example here is case management decisions relating to Section 67.
And Section 73 is not obviously a case management decision. I've got points of distinction on that and the policy of Section 73. But as I say, I'm running 2 points in effect, which is what is the policy of Section 73? And also, where do you draw the line under Section 67 in any event? Because obviously, if case management decisions are not caught, if case management decisions are not caught, and it is only decisions at the end of the process on the application, then logically, my Section 73 also fits with that.
Are you making a submission as to whether case management decisions are caught or are not caught?
So my submission is that they're not caught.
They're not caught.
They're not caught.
So if in the course of this Section 67 application there had been a case management direction...
Yes.
Well, let's take one which was in fact ordered for the hearing of a preliminary issue.
Yes.
And one side or other wanted to challenge that as being inappropriate.
Yes.
You could appeal that to the Court of Appeal
Yes.
with permission from the Court of Appeal.
Yes, that's my submission. Now,
what's the justification for if the ultimate Section 67 decision is not something is subject to the restriction? What purpose is there in making what
decisions
appear
along
to
the way?
be more minor decisions
Yes.
along the way to
It's
getting there, free of the restriction?
well, it's slightly, well, on the one hand, you might say that's, and I understand why it troubles the court, and I'm going to do the best I can to answer that. And I understand where, and as Lord Justice Mayles put a moment ago, and I would agree, of course, the court is the guardian and gatekeeper of the Act, and it wants to get the position absolutely right. So the way I would look at it, though, is that if that were the policy, which is decisions along the way, were being caught, why are there no restrictions in Section 66, 103 and 9? And that seems odd, which is why I asked, and when you look at the substantive cases on Section 73 itself, Mr. Justice Aiken's decision, Mr. Justice Coleman's decision, they all talk about the fact that finality of the award and knowing where the award creditor stands is quite an important consideration. And so, and I know that your Lordship is finding difficulty to accept where I'm coming from, but I am saying the policy is concerned at the end of the process and the disposal of the application. Now, I think there are cases which support this proposition. We'll test it and you'll see whether I'm wrong. And I think Section 69(8) also supports this, but I can understand why your Lordship finds it paradoxical to use the words of another Court of Appeal judge in the Peel case. If we can just turn to that for a moment, it's not going to help you a great deal, because as is described in the Manchester City case, there was a concession there, and so the observation of the Court of Appeal was the purest of pure obiter, and there wasn't much consideration, and I have to accept that. But let me just take you to that for what it's worth. Before I look at a few of these other points, and forgive me that I've lost...
Sorry, just before we
Yes,
leave Manchester, you say case management decisions are not caught. court,
Yes.
do you have to go that far?
I don't. I don't have to go that far. I am strictly limited. I only have to go as far as the policy of Section 73.
Yeah.
And so your lordships could come to the view that, and your apologies, your ladyship and lordships could come to the view that there's a particular policy in mind with Section 73, and that's different. And that case management decisions may be caught by Section 67.4. I have, therefore, two submissions, which is why I've been drawing two policy points along the way. But I thank your ladyship for seeking that clarification. Can I just very briefly take you to, if I can find my reference? Yes, so it's volume 3, tab 38. Now, as I say in advance, it's only one paragraph, page 846. So I mentioned that there's one other procedural bar that applies to sections 67, 68, and 69, which is the time bar, 28-day time limit. That's the other procedural bar, which is specifically cross-referred in section 67, for example. And then the court can grant extensions of time under section 85, where there are no restrictions on appeal. And Mr. Justice, I think it was Mr. Justice Akins, wasn't sure whether or not the Court of Appeal could grant permission. But if we look at paragraph 13, Mr. Derek Wood, QC, has appeared for the landlord, has conceded that there is in principle jurisdiction to grant permission to appeal. And of course that must be right. And this is what forgive me, I think it's Lord Justice Longmore. Yeah. Yes, this is what Lord Justice Longmore is saying. And of course that must be right, since section 85 of the 96 Act requires that rules of court relating to extending periods of time apply in relation to any time requirement. And so we have the slightly paradoxical, and section 85 contains no restrictions on appeal. Paradoxical situation that whereas the refusal of the judge at first instance on matter of substance cannot be reconsidered by this court, an application of a preliminary nature for an extension of time is apparently a matter which can be reconsidered by the court. Now, I can entirely accept that passage doesn't take or assuage or address the paradox that the court is putting to me. And obviously there was no full argument on this and so forth. But the court expressed an obiter view, at least, that the paradox was the paradox and was acceptable because section 85 contains no restriction. And the extension of time was being sought pursuant to section 85, which is the other procedural bar to a challenge under section 67.
How does this work? Because isn't the power of the court to extend time limits contained in section 79, which has the restrictions on appeal provision?
I thought it was section 85, and forgive me if I've got that wrong. Can I take you to the provision?
Yeah.
My lord. If I have now barked up yet another misguided tree, I apologise.
It may not be you. It may be me, or it may be this case. But
so section 80. So section 85 at page volume 5, tab 54, page 1324.
Yes.
Where any provision of this part requires an application or appeal to be made to the court within a specified time, the rules of court relating to the reckoning of periods and the consequences of not taking a step within the prescribed period, I see. So that's actually just talking about the reckoning of times. It's also talking about the substantive question of extending time, though. Yeah. So section 85 gives the power of the court to extend time without a restriction. What your lordship is referring to is power of court to extend time relating to the arbitral proceedings. I think that's in terms of with respect to the actual arbitration, underlying arbitration.
kind of extension of time court grant in relation to the? I mean, if the arbitrators say you've got to serve your pleading
Yes.
within 28 days,
It's not
the
that
court
sort
is
of-
never going
no,
to
no.
say you can have more time.
My lord, I'll have to come back to you. There is
Right.
a specific.
79(1) talks about extending time limits agreed by the parties.
Well, we may be getting a little bit far away from what we've
Yes,
actually got to
I
decide.
will come back to you on that if it's of assistance. There are specific provisions relating to the underlying arbitration, which I believe this provision has in mind.
Right. All right. Well, as I say, it may be that that's too peripheral to worry too much.
Section 85 is the one, though, with respect to extending times for appeals, to which Lord Justice Longmore's obiter observation applies for what that is worth, which I accept.
It's not worth very much because it went by concession.
I accept, my lord, and I'm trying to freely accept that
Yes. And
for the paradox.
any explanation of the paradox is just that's what it is.
Indeed, my lord, indeed. So I do appreciate that it's not much. Now, so can we turn to the language of section 69 and test whether or not any of that supports where I'm coming from or not? Section 69 is volume 5, tab 54, page 131. Sorry, 1311 and 1312. Now, the point I rely on is section 69.8, which is the restrictions on appeal at page 1312. Now, as the court is aware, this imposes a restriction similar to section 67 and 68, 67.4 and 68.4. But it says the decision of the court on an appeal under this section, which shall be treated as a judgment of the court for the purpose of further appeal, but no such appeal lies without the leave of the court, which shall not be given unless the court considers that the question is one of general importance. Now, that's the further restriction that your lordship was referring to. But the point I'm making is that the appeal restriction here is concerned with the question of law referred to at section 69.4, which is the subject of the application under section 69. Have I lost your lordship? Or?
It's the
No?
meaning of questions.
So you're saying, therefore, that can't apply to decisions along the way because that wouldn't involve an appeal on the question of law. Is that it?
So, my lord, indeed. It's at least surprising. Let's put it this way: why section 69 is limited to only restrictions on questions of the question on the application, and section 67 and 68 are not. That
69.6 says the leave of the court is required from any appeal, for any appeal from a decision under this section, to grant or refuse
leave to appeal, which is leave to appeal on the question of law.
Yes.
So it's again, but that's because obviously under section 69 there's a first stage permission, and then there's the permission at the end. So you need first.
Is one point that they've provided separately in subsection 6 and subsection 8, or have I missed something?
So it's unfortunately, my ladyship, it's me, which I'm sort of confusing the court. So section 69 is slightly different to section 67 and 68 in this sense, which is that there's a first stage to pursuing an application for an appeal on a point of law, which is you need the permission of the court.
Yes.
And so 6 is concerned with appeals from a refusal of permission, for which you need, but it's still on the question of law, because the leave it's concerned with any appeal from a decision of the court under this section to grant or refuse leave to appeal. So it's concerned with the leave on the question of law. So even at the first stage, the restriction is on the decision, on the application,
Yeah.
and the same applies at the second stage under section 69A.
My point is that they've
Apologies.
expressly provided that one decision that might be regarded as a decision along the way, which is whether to grant leave,
That's
they've
also
made an express provision in subsection 6.
my ladyship. Obviously, I will take the. I
Well,
will grasp that.
whether it's a good point or
I will
not,
grasp
I don't
that
know.
and gratefully adopt the point, which is it has, in this particular case, and specifically enshrined a decision along the way on the substantive application, a specific one, which is the first stage in the process, for leave to be granted, for there to be a restriction on appeal. So the question I ask, and that's why I ask what the policy is and where the policy line is to be drawn. Is it along the way, or is it about finality at the end and avoiding delay at the end? And I quite understand that the court finds it difficult to understand, or from a rational perspective, why decisions along the way are not caught. But my answer to that is simply that there are other mechanisms to deal with that situation, which is the tribunal can continue. So the Act, from its perspective, is not concerned about that. What it wants is closure at the end of the process. That's the way I'm putting it. Of course, I've got my freestanding point that Section 73 has got a complementary policy in favour of the award credit. Now, so what more can we derive from the language of Section 67? The only points that I make are these. Obviously, Section 67(1) tells us what the subject matter with which Section 67 is concerned, which is applications effectively by the award debtor challenging any award as to its substantive jurisdiction. Now, it does refer, like Section 66 that I've already taken you to the fact that a party may lose the right to object, and the right to apply is subject to the restrictions in Section 72. Those are the procedural restrictions, 72 and 73 being the time bar. But in my submission, it's not linking. What I say, it's only linking. It's purely descriptive in the sense that it's not linking Section 73 decision as opposed to the outcome. Because it says may lose. So if it does lose, it has an outcome on Section 67, but otherwise it does not. So when we've already looked at Section 67(2), which is the point about the fact that the tribunal can continue. And so the question then arises, the leave of the court is required from any appeal from a decision of the court under this section, whether under this section means anything along the way, or simply a decision on the application, which is what effectively I'm saying. Now, just for your note, again, your lordships may tell me that doesn't take you much further, but let's have a look. If volume 5 of the legal authorities at tab 68, Stroud's Judicial Dictionary, it's just a very general point, but this is page 1553. So if we look at the decision, it says, decision was held to be a popular, not technical work and was said to mean little more than a concluded opinion. But in modern times, the cases are broadly divided into those which give the word a narrow meaning akin to judgment, and those which give it a wider meaning to take in much more so. So you can see the examples that are given. Little b, for example, under the Bankruptcy Act, a refusal to extend time for an appeal was not a decision upon an appeal. C, in the Land Tribunal's decision meant final decision and not an interlocutory order. And if you look at E, for example, under the Senior Courts Act, decision meant final decision, not a preliminary ruling. Now, of course, that doesn't ultimately answer the question that this court has to address. But the point I make is that decision can mean different things in different contexts. And sometimes it means interlocutory decisions, and sometimes it does not. Now, so, I now need to take the court to the two Court of Appeal authorities, which were not referred to in the Manchester City case, because I suppose they weren't directly pertinent, but which in my submission, and we'll see, support the proposition that one's looking at the question of whether the application of the award debtor is being disposed of. So the first one is ASM Shipping, which is in Volume 1, Tab 5. And if I may just briefly give you the facts, and then we'll look at the relevant parts of the reasoning. So this was a case challenging an award under Section 68 of the 96 Act, which has the same restriction as Section 67 in Section 68(4). The award had been challenged on the grounds of apparent bias of the arbitrator. And you can pick that up from paragraph 2, which gives some description of the alleged bias of the arbitrator, who we a well-known arbitrator and counsel, of course, because of his sitting in another arbitration and his knowledge of a particular witness. Now, the point, the arbitrator declined to recuse himself, and rather than applying under Section 24 of the 1996 Act to remove him, the ship owners who were complaining took up the award. So what happens if you go to paragraph 6? What happened as a result, by taking up the award and not challenging the arbitrator under Section 24, the judge, as we can see at the bottom of paragraph 6, held that the serious irregularity of apparent bias had been waived. And so he dismissed the shipowner's Section 68 application on that basis, by reason of waiver. Now both my learned friend and I rely on paragraph 9, but before we come on to it, can I just emphasize again, at the bottom of 6, the judge therefore held that the serious irregularity of apparent bias had been waived, and that was the reason why he dismissed the shipowner's Section 68 application. I emphasize the word Section 68 application, and I'll explain why when we go to paragraph 9. So if we go to paragraph 9, what is said here is, there is no doubt that Morrison J had a jurisdiction either to accede to the application, that is the Section 68 application in my submission, or to refuse it. Whichever way the decision went, it was still a decision under Section 68 of the Act, and a refusal of permission to appeal was likewise a decision. It cannot therefore be challenged by way of appeal, even if the decision is wrong. The fact that the waiver can be said to operate as a defence to a prima facie entitlement is, in our view, nothing to the point. A decision to refuse relief is still a decision. So what is being focused on there, and I accept that we're not in the same situation because waiver was found as opposed to it being rejected. But what is being focused on is the effect on the application. That's the point I draw from it.
Well, what about the previous words, whichever way the decision went? That's the point against you, isn't it?
I submit that what is being said is whichever the way the decision on the Section 68 application, it could have been either accepted or refused, because if there hadn't been waiver, it would have been accepted by reason of the bias. Because the judge found apparent bias, but rejected it on the grounds of waiver. So my submission, and actually is not whichever the way, what I think NEOC is submitting, what your lordship is putting to me, is that when it says whichever way the decision went, that is a decision on the question of waiver, whereas I read it saying whichever way the decision on the Section 68 application went.
Yes, I see.
That does seem to be supported by the final sentence. The decision to refuse relief is still a decision under Section 68, just as much as the decision to grant relief would have been if a decision had gone the other way.
My lord.
And I think you accept the same applies here, that if your Section 73 application had been successful, that would have been subject, that would have been a decision to refuse relief and would have been subject to the restriction in 1667.
Against the ward debtor.
Your point
But that gives the paradoxical point that your lordship is putting to me.
Your point is that since the preliminary issue was answered against you, it didn't amount to a decision under Section 67 one way or the other. It just allowed it to go forward.
My lord.
Well, I see the way you put it.
I'm grateful for that, my lord.
That's as much as you can ever ask for.
Now, I'm conscious of the time. I wanted to go to the other decision, so I think that should be after the lunch break.
Yes, all right. Well, we'll adjourn till 2 o'clock.
Court is able.